Before Donald Trump, the last time that American politicians attempted to subvert the elected government and unleash violence in response to an election was, of course, the Civil War. And in the wake of that, the founders of the post-Civil War republic, the framers of the 13th, 14th, and 15th Amendments, were quite preoccupied with the fact that those who fomented bloody insurrection and rebellion against the country should be disqualified from future office. In fact, they were so concerned with it, they wrote it into the United States Constitution as Section 3 of the 14th Amendment. No person shall hold any office who, having previously taken an oath to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same or given aid or comfort to the enemies thereof. Now, two conservative law professors, self-professed originalists, have published a law review article arguing that, quote, if the public record is accurate, the case is not even close. Donald Trump is no longer eligible to the office of the presidency or any other state or federal office covered by the Constitution. One of the people who's been working on this issue, Section 3 of the 14th Amendment, Noah Bookbinder, president and CEO of Citizens for Responsibility and Ethics in Washington, or CREW, and he joins me now. Noah, it's great to have you. First, just tell us what you were able to do, because you brought a suit under this, part of the 14th Amendment, that was successful, and I think the first time that it's happened in many, many years. Tell us about that suit.
Yeah, that's right. So we represented residents of New Mexico who brought a lawsuit to remove from office and disqualify from future office a guy named Couy Griffin, who was a county commissioner in New Mexico. He was the founder of a group called Cowboys for Trump, and he was someone who was on the steps of the Capitol on January 6th. He helped to recruit people to the Capitol on that day. He encouraged violence and insurrection. He normalized that violence, even though he was not personally violent. And we were able to convince a court that that January 6th was an insurrection for the purpose of the 14th Amendment, the first court to find that, and to disqualify Mr. Griffin from office. It's the first time in over 150 years that a court had disqualified someone under the 14th Amendment. So that's incredibly significant in showing that this is a living piece of the Constitution that applies as much now as it ever has. How did the
lawsuit work? How did you sue him, and in which court, and how did you bring it?
Yeah, so in New Mexico, there is a law, and a lot of states have these laws, that basically say that citizens can go to court if there is a person who is not qualified to serve in the office in which they're serving. And so the case went to state court in New Mexico. A judge heard evidence. They heard witnesses and considered the evidence, considered Mr. Griffin's defense, and made this decision. And it will be, because we have every intention, we're preparing to take action to remove Donald Trump from ballots under this provision, a similar kind of provision to show that he is not qualified to be on the ballot for president because the Constitution says that he cannot serve.
So that's the big question. You've got a law review article. You've got the plain reading of the text, which I think is a plausible case. How would it even work at the federal level? What would be the actual legal mechanics by which this law would be rendered real with respect to Donald Trump?
So obviously we're on ground that hasn't been tilled in a very, very long time. But every state has laws and has procedures for who is qualified to be on a ballot. So, for instance, and this has happened, if a 31-year-old runs for president, the Constitution says you have to be 35. The procedure is a little different in different states, but a citizen can go to court and say this person's not qualified, and a court will hold an evidentiary hearing, look at the evidence, and make that determination. Also, a Secretary of State, the chief election officer in a state, can make that determination themselves. They can say, again, this person's 32 years old, they can't be president, so we're going to take them off the ballot. The same thing applies here, even if the stakes seem a lot higher. It's really the same kind of qualification from the Constitution.
Yeah, Crew, for whom you work, has written that Section 3's text and historical applications make clear that a criminal charge or conviction is not necessary for a person to be adjudged disqualified. Section 3 can be adjudicated through civil lawsuits. And with respect to presidential candidates, the disqualification clause can be enforced by, as you said, state election officials and in state courts as part of the process for determining who can appear on ballots for presidential elections. Final quick question for you. You got to do it ahead of time, though, right? Like, you can't do it after. It's like, it's got to be this question of, can they appear on the ballot as a front end question?
That's right. I mean, you can go to try to remove someone from office once they're in office, but that's obviously a much more explosive situation to end up in.
Yeah.
When you have someone who shouldn't be qualified, you ought to get in there soon. That's what we intend to do, and we hope that, and we trust that courts and that election officials will follow the Constitution.
This is a real sleeper issue that we're going to stay on because I think it could be quite explosive as it proceeds. Noah Bookbinder, thank you very much.